Good morning, good afternoon, and good evening. Welcome to Seminar D of the Monique and Roland Weyl People's Academy of International Law. My name is Marjorie Cohn, and I'm Dean of the People's Academy. Our topic for today is the crisis of public international law, the case of Palestine, and impunity for genocide. Our faculty for this seminar includes Raji Sourani, Francesca Albanese, Shahd Hammouri, and LaHood. More than 15 months of Israel's accelerated genocide against the Palestinian people, unrestrained by effective legal accountability, has exposed the world to a terrible crisis in international law. The International Court of Justice has ordered preliminary measures declaring that South Africa's case against Israel for genocide is plausible, while the International Criminal Court has issued arrest warrants for Israeli Prime Minister Benjamin Netanyahu and former Defense Minister Yoav Gallant, charging them with war crimes and crimes against humanity. The International Court of Justice, in a July 19, 2024 advisory opinion, determined that Israel's occupation of Palestinian territory, including Gaza, the West Bank, and East Jerusalem, continues, is illegal, and must stop. Against the backdrop of legal decisions and incontrovertible evidence of genocide, the United States, Germany, and other states have continued to provide Israel with billions of dollars in weaponry. And the U.S. even invited Netanyahu and other Israeli politicians to be honored in the U.S. Congress. The illegality of Israel's genocide, crimes against humanity, and war crimes against the Palestinian people is obscured by claims advanced by the U.S. and other states that the Israeli war, which has been determined to be plausible genocide, is just part of a so-called rules-based international order. Domestic and international institutions and legal systems have appeared largely co-opted by the United States. It is reported that a 42-day ceasefire agreement between Israel and Hamas will go into effect on Sunday, January 19th. It includes the freeing of 2,200 Palestinian prisoners and 33 Israeli hostages. The first phase will include a withdrawal and redeployment of Israeli forces outside densely populated areas. Internally displaced people in Gaza will be allowed to return to their homes, and increased humanitarian assistance will be allowed to enter Gaza. This is a practice-oriented seminar and discussion about what meaningful utility remains for international law and legal institutions in a time of genocide and impunity. I'm going to tell you a little bit about our distinguished faculty for this seminar. Raji Sourani is director of the Palestinian Center for Human Rights, and he has received widespread recognition as the Gaza Strip's foremost human rights lawyer. Raji has been imprisoned on 6 occasions, the longest for a period of 3 years, and he was named a prisoner of conscience by Amnesty International in 1988. He was awarded the Joint Laureate for Robert F. Kennedy Memorial for Human Rights in 1991, and he has received several other human rights awards throughout his career. Since 2015, Raji has been a counsel at the International Criminal Court, and he is coordinator of the Palestinian team that is representing the Palestinian victims at the ICC. In 2024, Raji became a member of South Africa's legal team in the genocide case against Israel at the International Court of Justice. Days after the war erupted on Gaza on October 7, 2023, Raji and his international legal team at the ICC were the first to publicly describe the war on Gaza as a genocide. On October 29th, while he was home with his wife Amal and son Basil, a 2,000-pound bomb was dropped on their house. They miraculously survived but were forced to leave Gaza. Despite periods of political imprisonment in Israel, years of harassment and violence by the Israeli military, harassment by the Palestinian Authority, and even death threats from Palestinian fundamentalist parties, Raji has maintained an unwavering commitment to human rights. He has been an advocate for basic human rights, both on the domestic and international levels, and has refused to curtail his outspoken criticism of failures by Israel, the Palestinian Authority, political parties, and other states to adhere to human rights standards. In spite of all the obstacles he has faced, Raji continues to promote and protect human rights through the Palestinian Center for Human Rights, which he founded in 1995 with a group of fellow lawyers and human rights activists in the Gaza Strip. Raji has spearheaded this award-winning center since its establishment and continues to ensure that the center provides legal and other services to victims of human rights abuses in Gaza, enabling them to seek justice and reparations. Throughout the challenges and the years of the Second Intifada, and during all Israeli offenses on the Gaza Strip, Raji has remained stalwart in his determination that the center will continue to provide services to the maximum number of victims and bring their cases before the ICC to achieve justice and accountability for Israeli officials accused of justice to the victims and accountability to Israeli officials accused of crimes committed in Gaza and throughout the whole occupied Palestinian territory. Today, Raji will analyze whether the International Court of Justice and the International Criminal Court are providing accountability for Israel's genocide and illegal occupation. Francesca Albanese is an international lawyer specializing in human rights and the Middle East. Since May of 2022, she has served as the United Nations Special Rapporteur on the situation of human rights in the Palestinian Territory occupied since 1967. An affiliate scholar at the Institute for the Study of International Migration at Georgetown University, Francesca is the author of prestigious publications, including Palestinian Refugees in International Law, which was published in 2020 by Oxford University Press and is considered a landmark in the literature, and other academic works on the legal situation in Israel, Palestine, and Palestinian refugees. Since 2018, Francesca has taught and lectured at various universities in Europe and the Middle East. She oversees the research and legal assistance program on migration and asylum seekers in the Arab world for the think tank Arab Renaissance for Democracy and Development. And she is a co-founder of the Global Network on the Question of Palestine, a coalition of prominent regional and international experts and scholars on the issue of Israel-Palestine. Francesca has worked with the United Nations from 2003 to 2012 in the Office of the High Commissioner for Human Rights and the Relief and Works Agency for Palestinian Refugees, or UNRWA. As Special Rapporteur, she has published numerous legal opinions and 4 major reports on self-determination in 2022, deprivation of liberty in 2023, of violated childhood in 2023, and genocide in 2024. Francesca will discuss her new comprehensive report documenting how Israel is committing genocide in Gaza, the West Bank, and East Jerusalem. Dr. Shahd Hammouri is a lecturer in international law and legal theory at the University of Kent in the UK. She is the author of the forthcoming book, Corporate War Profiteering and International Law. She is also a senior legal consultant at Law for Palestine and a non-resident fellow at Al-Haq. Shahd will address the right of self-determination as decolonization. Maria LaHood is Deputy Legal Director at the Center for Constitutional Rights, a New York-based nonprofit which works with communities under threat to fight for justice and liberation through litigation, advocacy, and strategic communications. Maria joined the center in 2003, where she has sought accountability for international law violations and defended Palestinian rights advocates under attack in the United States. She is also a founding board member of Palestine Legal and a member of the task force of the People's Academy of International Law. Maria will explain the litigation filed by the Center for Constitutional Rights and others to hold Israel and Israeli leaders accountable, and she will discuss bringing lawsuits under universal jurisdiction. Raji, you're up.
Thank you so much, Marjorie. And I would like to begin with saying I spent the last 4 to 5 years working as a lawyer in defending Palestinian victims in the occupied territories, particularly in Gaza. In the very beginning of my career, many, especially Americans and Europeans who work in international organizations, were criticizing us. Why don't we use the fantastic Israeli legal system? And they said this is one of the best, and this is the model, for the Middle East. We know in advance that justice and dignity never can be achieved under criminal belligerent occupation as such. But we decided, to go with this experience, and we concluded in simple words that the Israeli legal system provides full legal cover for organized systematic war crimes, crimes against humanity and persecution of the Palestinian people. Then we decided to resort to universal jurisdiction. After we exhausted all ways and means, we found that many of the European countries and US began to change the laws there, especially in Switzerland, UK, Spain, Netherlands, New Zealand, and we managed to do some success in these cases. But the real obstacle was simple, that there was very serious political weight to block us from using universal jurisdiction in these designated countries. They provided legal cover, political cover for the Israeli and the Israeli leaders. That's why we began to think seriously and began to seek different paths. ICC, and on the offensive of 2008-9 on Gaza, Castlet, we began to address the ICC. And I remember, in simple words, at Pilacio, Italy, the prosecutor then told us in simple words that if in any case presented to the ICC prosecutor office, no American consent and approval, he will not move with the case. And after that, he publicly put in a press conference 5 conditions for Palestine to join. And that took us years to overcome these conditions. And only after 2014 war, and in January 2015, in January, we managed to have Palestine as a member, and we began to engage with the ICC. It took us 5 years of work just to conclude the preliminary investigation. But during this period, there was direct and indirect threat to Fatou Bensouda, the prosecutor at the time. She was threatened by Israeli, American, and Western diplomats. And she filed complaints, on this, and the Dutch government, which should be the host country to protect the ICC and the prosecutor office, actually did nothing almost to protect her. And all of us aware about the very famous presidential decree by Trump, where he threatened the ICC prosecutor and the staff and the judges that if any do any harm to US or Israel, that they will hold them accountable through specific measures against them. Now, Fatou Bensouda referred the case in 2021 to the pre-trial chamber, and the pre-trial chamber concluded that the Rome Statute do apply in Gaza West Bank, including Jerusalem, and she tried to avoid a real obstacle might come in the future, and some suggest that Rome Status doesn't apply in the occupied Palestinian territories. And she formed the investigation committee before she left. And then Mr. Karim Khan took over. And when he took over in June 2021, we were expecting him to do something special, unique, because all the road was passed and ready, steady to go. The primary investigation has been concluded, and the pre-trial chamber assured that the jurisdiction apply in the occupied territories. The investigation committee was formed, and on what he should do, just give the order to make things, go. Unfortunately, for 2 years, we were trying only to see him, to meet with him, and to tell him about the urgency and the need that he should investigate and proceed with the procedure. Regarding the occupied territories, he didn't listen to us. Meanwhile, there was the Russian-Ukrainian conflict erupted, and promptly, immediately, and after 43 days, he opened an office in Kiev, and he installed as much as 45 staff belongs to the ICC to begin investigating and collecting evidence. And after 1 year of that war, a warrant was issued. This was great, and we were happy, and we wanted to see that really, working, and we were encouraged, and we said to ourselves, great, Europe and US, be aware about what's happening, about the importance of the ICC, about the importance of the Rome Statute and international law. They are against invasion, they are against occupation, and they want to move in this direction. But unfortunately, this was for Ukraine. For Palestine, the situation was still the same. When October 7th happened, we in 2 weeks were sure almost of genocide. And as Marjorie suggested, while we were watching and monitoring what's going on, documenting what's going on, we realized that the genocide was taking place, which was a great shock for us. And we formed a group on 16th of October, includes top-notch academics, jurists, lawyers, human rights activists, where almost 24 of us were in consensus that this is genocide. And we began to contact again the ICC, prosecutor, and the investigation committee, and nothing moved. And we came to a situation that we realized that ICC prosecutor, he will go nowhere. And that's why we have to find another way. And that's why we began to think of resorting to Ireland, to South Africa, or some other state. And lucky, and to make the story short, South Africa expressed its readiness to go with the file, and they began to form the legal team, and they began to build the file, and we cooperated fully, and the team was super fantastic. team, combination of South African and Irish and Palestinian lawyers who were able to do that. And in 29th of December, the case was filed at the ICC and accepted. And on January 11th, the session was there. And I think South Africa in January 11th, with all its moral, human, political weight, with all the heritage of struggling anti-apartheid colonialism, the moral authority South Africa do have, it just expressed really and used it effectively by explaining the live stream genocide going on Gaza, and it represented it in the most fantastic way we Palestinians, or we as jurists of the globe, can imagine and love to have it as such. I was very proud as a Palestinian and as somebody who believed really and worked all his life for justice and dignity of victims. The court accepted it, and in 26th of January, there was simply a session for provisional measures, and the court ordered Israel to apply what was there to allow humanitarian aid, to allow food and medicine, to go to Gaza, to allow accessing, to have an end for the starvation. But unfortunately, Israel didn't listen, didn't react. And the states of the world, same thing. They didn't do the basic fundamental obligation, legal obligation they have by pressuring Israel or do anything to enforce Israel to apply the provisional measures as it has been asked. This was repetitive in March. In April, 2 provisional measures were issued by the court, and Israel didn't listen, and the world community didn't apply. Now, ICC prosecutor felt the heat and saw how Israel was charged with the genocide, and the court accepted that. And there was a provisional measures, and that's why he asked to see us, and we talked about that. And one of the things we said to him in the very beginning of the meeting, the blood of children and women on Gaza on your hand. You are acting too late, and no excuse for that. Within Rome Statute, within your mandate, you have to act against genocide. And this is live stream genocide. And you have everything which prove that Israel is doing genocide. And you didn't act, you didn't react. Even by having 2 of the chain of command, not accused of genocide, but accused of war crimes and crimes against humanity, for me, is not enough. The facts are there, the informations are there, first-class legal files are there, first-class evidence are there, the factual, the intent in a classical genocide case is there to act, and he can issue tens and hundreds, especially on the level of intent. Everybody in the state of Israel, hundreds of the political leaders, of ministers, of political parties, of Knesset members, of the army, of the security, said and speak loudly and clearly about the intent of genocide. Now, we have simply, as romantic revolutionary says, and as lawyer says, simple formula. There is facts, there is standards, and there is conclusions. The facts are there, and the standards are there, and the conclusion is simple. Israel is doing war crimes, crimes against humanity, persecution, and all the components of the genocide. And this doesn't even need neither first-class lawyers or academic. It's streamed live. Is Gaza the graveyard of international law? Did we invent the Palestinians, the international law, and the Genocide Convention? I think we deserve, as part of the world community, as some people who face injustices, who face ongoing war crimes, crimes against humanity, persecution, and genocide, justice. I think the Israeli leaders and the Israeli state both deserve accountability, and they should be held accountable for what they are doing. And I think the question we are having, it's not only for Palestine, it's for the world community. What world we want? Do we want world with rule of law or world of rule of jungle? I think we cannot be selective, neither schizophrenic. The worst thing that I remember when I was a student at the School of Law, we were studying the history of law, and one of these things were about Rome, and how in Rome there was two classes, masters and slaves, and only masters who enjoy the protection of rule of law. Are we, the Palestinians, the slaves of the 21st century? Is Gaza the real, rude, bold example that Gaza will be the graveyard of international law? I don't think this will be in interest for anybody. We have, as a human rights defenders, as people who believe in the slogan of rule of law, as people who care about justice and dignity for the victim, we have no right to give up. And we have to keep the fight for the rule of law. And we cannot and should not be good victims for genociders, for the criminals. Accountability, it's a must. Marjorie was talking about ceasefire. This morning, 2 a.m., my personal assistant, 33 years old, full of life, energetic, fantastic person, passionate, works 12, 14 hours a day, even under the bombing and under the hell Gaza having. Quadcopter came into his room, bombing him, his wife, 29 years old, his daughter, 6, the other daughter, 4. And all of them in 1 second died. They declared ceasefire yesterday. 77 people died. Gaza cannot and should not and will not be the graveyard of international law. We will have no dignity if we give up, if we didn't bring those who turned Gaza entirely to an uninhabitable place. No school, no clinic, no hospital, no electricity, no water. 90% of Gaza erased and destroyed, including streets. 17,000 children died. 17000. 14,000 women. How much they want children and women and innocent civilians to die. Displacement, 2 million people are displaced. Not once, not twice, not 5 or 6 times. Most of them 10, 12, 14 times. Like lost goat, they are running just from one place to another. Incredible conditions. Besides the displacement, starvation. And I don't mean starvation for food. No, I'm talking about basic bread. It's very hard for a family to find some bread for 4, 5, 6 days. It's not because of lack of humanitarian or food. It's not allowed. And if they come in, they will bomb the convoys inside Gaza. They will kill the people who are going to take these aids. It's a big shame. This is happening now. This is happening today. This is happening for the last 15 months, and no one able to stop this evil. not only not able to stop them, but they are protecting them. And they say, you do have the right of self-defense. Criminal, belligerent occupation do have the right of self-defense. What a shame. It's not only having the right of self-defense, but they are providing full political cover for them, as did all the way long at the Security Council and other places. Not only that, till this moment, we are killed by American, British, German, French, and Dutch arms and bombs. They are not complicit. They are partner. Gaza should be the test case and big outcry for humanity and for those who believe in justice, rule of law, and dignity of man. That Gaza shouldn't be the graveyard of international law, and it shouldn't. Thank you.
Thank you, Raji. I'm so sorry to hear about your personal assistant and his family, and thank you for describing some of the horrors taking place now, and also for explaining the challenges that what you call romantic revolutionaries face in holding Israel accountable in the ICC and the ICJ. Thank you so much.
Shall I go next? Okay. So thank you, Shahd. Thank you, Maria. First of all, let me express my condolences to Raji and for yet another loss that he has suffered. And it's incredible how much this continues to be the monstrosity of our century. And it's critical to remember. I mean, I have refused to take any interview today from the media because, frankly, I don't know what to say. I mean, of course, I'm happy to see people, surely in Gaza, but also in Israel, rejoicing for the ceasefire. But Israel has killed 80 people in less than 24 hours in Gaza. And this is just in the spirit of good faith toward and of maintaining calm, creating the conditions that make the ceasefire possible, and let alone what's happening in the West Bank. So it's really with a heavy heart that I look at the current developments. And so let me elaborate, let me share the remarks that I had prepared on my fourth. In fact, I've written 5 reports as a special rapporteur. I'm almost at midway into my mandate. My next report will be the 6th, marking my half term. So my 4th and 5th report to the Human Rights Council first in March and General Assembly, the United Nations, in October 2024 were about genocide. The first report was called Anatomy of a Genocide, and it's very much what it is. It's an X-ray of what Israel has been doing to the Gaza Strip over the first 5 months that followed the violent attack Israel suffered on October 7. No question, I have condemned the attacks of civilians, the killing of civilians, the taking of civilian captives in Israel, as I have condemned the killing and taking of civilian captives for years at the hands of Israel. So, but what ensued, the October 7 attack, has been violent vengeance, and it has entailed crimes after crimes. In the first 3 months of the war that Israel launched against Gaza in response to the attack suffered on October 7, which was repelled. By October 9, Israel had repelled the attack, had killed thousands of fighters, had no fighter presence in the territory anymore, neutralized the threat. Why did he start a war? He started a war which was like no other war. It cut electricity, food, fuel, and medicines. And it said so. It announced that, quote unquote, the human animals in Gaza would pay for what they had done. And similar language was used by dozens of Israeli leaders in the aftermath of October 7. A nation of non-innocents, and there is no uninvolved civilians. It's a nation responsible. We should break their backbone. and erase Gaza, bomb Gaza, destroy Gaza became the cry of the war, for that war, resounding across Israel, north to south, east to west, vice versa. Of course, the Israelis were profoundly wounded, and I don't think that we can engage with this question without understanding how dramatic that day has been for the Israelis. And of course, I do not say that to justify, but because moving forward, I'm interested in the way to change the reality. And right now in Israel, and there is no change of mentality. Many people are protesting to end the war because the war has wreaked havoc to Israel as well in many respects, economically, especially the families of the hostages want the hostages back. But this is not in the name of solidarity with the Palestinian people, empathy with the Palestinian people. Of course, there is a minority who's denouncing the genocide, and they need to be acknowledged. But what has happened? Why do we speak of genocide? And 1 year later, and 15 months later, I can tell you, I'm definitely not alone in saying so, and we will get to this. But Israel, in the first 3 months of this attack, have killed an average of 250 persons per day. And steadily, from the beginning, the death toll has been made of 70% women and children. This is a figure that the High Commissioner for Human Rights has reported in October 2024. Constantly, special rapporteurs, including myself, about 30 of us, the majority of us, has documented and reported these figures, saying there is something completely wrong. The targeting is so indiscriminate, it's so wild, that there is no precaution, no protection. Each military operation needs to respect basic principles of proportionality. The military need that is to be achieved must be proportionate to the damage that is caused, or is to be proportionate to the military gain. But the military gain is to be clear. There should be always a principle of distinction between civilians and combatants, active combatants. There should always be a principle of precaution, taking precautions to protect civilians. And we've said, well, how come 250 people per day are killed and 70% of them every day are women and children? And we cannot think that the other 30% is clearly made of active combatants, because there are elderly people, there are disabled people, but plus it's not that every man is a combatant. And again, this is always considering that was a legitimate war, which for me it was not. I kept on saying from the very beginning, this is not a war of self-defense. Self-defense is something else, but we can get back to this. So during the first 3-4 months of this war, Israel had used a quantity of ammunition, bombs, and other forms of weapons against the Gaza Strip, 360 kilometers, which was equal to 2 nuclear bombs. And by May, the quantity had become, the weapons used equated the damage caused by 5 nuclear bombs against an entrapped population in a small piece of land. The bombardment has caused mass destruction to the civilian infrastructure. All universities, 11 universities have been erased. All hospitals. There are 16, they are still functional, but to the minimum capacity. They're not even proper hospitals anymore. I mean, today Amnesty International was reporting and sharing some facts on their incredible, and I recommend its reading, incredible report about genocide, which is much more comprehensive than anything I've read so far. And it says we have, it reports testimonies of doctors who had to operate, to amputate, most of the time children. 1 out of 3 children has been amputated of at least one limb. And sometimes to disinfect, they only had vinegar, no anesthesia. So this has been ongoing since December last year. Of course, that's changed in some hospitals. They received some medications, in others didn't. It's been a total catastrophe. We got to 30,000 people killed by March 20. 2024. And I said, it is genocide. I do believe that there are reasonable grounds to say that Israel has committed genocide, because genocide is the intent to destroy a group in total or in part as such. What kind of group? National, religious, racial, or ethnic group. So it's the intent to destroy. So this is why genocide is such a complex crime, because it's complex. Should be impossible to commit genocide. The only thought of genocide, not the only thought, the manifest thought of genocide can be considered like incitement and should be punished. And then it manifests through various acts of killing members of the group as such, causing severe bodily or mental harm to members of the group, or creating the conditions of life leading to the destruction of the group, and also prevention of birth and the transfer of children. Chances are that all these acts have been committed, because there are reports that I've personally not been able to investigate, but I hope there will be others, of various kids who have disappeared, who have been photographed in the hands of soldiers and then they have disappeared. But the cases of persons who have disappeared from Gaza are countless. We don't know if they are under the rubble, if they have been arrested. We don't know if they are detained in Israeli jails, which have been transformed, according to Israeli NGO B'Tselem, into a network of torture centers. And so by then, also, I think 70,000 people had been injured, many of them for life, with life-enduring injuries. Again, the mass destruction, as I said, the universities had all been destroyed before March. And Gaza, as Raji often mentions, was the place with the highest number of people with a degree, because education has always been important for the Palestinians, especially for Palestinian refugees, and Gaza was made of 75% of refugees from modern-day Israel. So the thing is that the intent had translated into practice. It was said and it was done, and there was plenty of evidence. By then, the South Africa legal team had collected already hundreds of testimonies and hundreds of videos that proved the connection between words and actions of the soldiers. So the soldiers had acted not to carry out the war, but to carry out a campaign to displace, occupy, and settle. And the key word of the first months of genocide was Amalek. Amalek, every genocide has its own terms, like it was thousand hills, les mille collines, chop the tall trees. The tall trees were the Tutsi in Rwanda. Here, the call for genocide has been destroy the Amalek, this biblical term which is associated with the enemies of the Israelites in the Bible, in the Old Testament, and the call for destruction is go and destroy the Amalek, the mother, the suckling, the donkey and the camel and the rest. So it's a call for full destruction. Besides the shock of seeing genocidal calls in the Bible, I was even more shocked to see that in 2023, young people could do that. And yeah, they have done it. And they have been transformed into willful executioner. What I also said in the first report is that Israel had not only committed genocide with full knowledge of what they were doing, because trust me, Israel has excellent lawyers. I recommend everyone to watch this documentary, The Law in This Part. It's quite old. It's at least 15 years old. But it explains how Israel from the beginning has used the law and twisted the international law, humanitarian law, the law of occupation and the laws of war to forcibly displace the Palestinians in the West Bank, to get more land and to establish its presence in the occupied Palestinian territory, West Bank, Gaza, and East Jerusalem. But this is the thing. It has incredibly brilliant lawyers. So they know what they have done. And the thing is that instead of, Israel has not denied to carry out that violence. It does justify that violence by saying, we issued evacuation orders. Yes, for 1 million people, including sick patients, doctors, nurses, elderly, disabled people who had to leave the land, the entire half of the West Bank in 24 hours. Otherwise, they would be deemed associated to Hamas, therefore killable. And this is what has happened. While almost 100,000 moved, 400,000 didn't, so they remained in northern Gaza. And they have been exposed to the utmost violence. And many have been arrested and tortured, including journalists and doctors. Over 1,000 doctors have been killed, medical personnel have been killed. Over 200 journalists, over 250 UN personnel. I forgot the numbers of university professors, musicians, scientists who have been killed. But Israel has intentionally devastated the Gaza Strip, the Gaza society. It will be difficult, ceasefire or not ceasefire, it will be difficult for Gaza to go back to what it was. It will never happen. So genocide has happened. And Israel, this is what I was saying in the first report, has used what I call a humanitarian camouflage, has made up terms that are from international humanitarian law to justify its operations. Evacuation orders, humanitarian zones. Humanitarian zones have become death zones. They've been hit hundreds of times. And this is documented not just by me, by Amnesty International, by Forensic Architecture, which has written a report, Cartography of a Genocide, that documents extraordinarily well the various instruments that Israel has used to commit this genocide and how it has reduced the Palestinian population to an unlivable space where they can only survive till they die. Because in Gaza, Palestinians have been killed not only by bombs and snipers. We say 47,000, but in fact, the estimates now is that this number is lacks a 40%. It's 40% higher. So there would be over 70,000 Palestinians who have been killed by bombs and sniper fire. And then this doesn't account for those who have died because of infection after being amputated, operated, because there were not enough medications in Gaza. Those affected by chronic diseases, leukemia, cancer, diabetes, who couldn't do dialysis, cures, chemotherapy, etc. And therefore, go out for chemotherapy because, many treatments were not available in Gaza, including before October 7. Everyone has been trapped in Gaza, especially after the takeover of Rafah. So I said, Israel uses humanitarian camouflage. It uses concepts of international humanitarian law to justify the violations that it commits. Human shields. Every Palestinian is a human shield, therefore killable. And if it's not a human shield, which is to be proven under international law, it's not that you can assume that everyone is a human shield. Either people were human shields or they were collateral damage. Halas. I've seen lawyers, people who call themselves legal scholars and write on so-called reputable law reviews, writing, debating, pontificating on whether killing 100 people while targeting one alleged Hamas commander was proportionate. For me, this is the end of international law. When someone with a law degree can remotely justify this. Sorry, I get upset when I think of the monstrosities that my fellow lawyers can say and think. But however, after this, I didn't think that I would have to write another report on genocide, and there I was. Few months later, still documenting the killing, still documenting the lack of compliance with the ICJ provisional measures, the ones that were issued on an urgent basis without the ICJ even looking at the merit, but recognizing the plausibility that acts of genocide were being committed. It issued a set of preliminary measures in January, in March, in May, everything neglected. There was a call for ceasefire by the Security Council in June. There were the ICC arrest warrants demanded by the prosecutor. As Raji has said, nothing stopped the assault, which continued. And this is where I felt compelled, at least for justice, because one day there shall be justice. And I said, we need to properly understand why this cannot be missed. Yeah, while the ICC investigates and while the ICJ deliberates, they need to understand that the genocidal intent in this one in particular cannot be missed, because this is a classical example of settler colonial genocide, where the genocide is committed as part of a political project, or as part of a political project. Of course there are war crimes, of course there are crimes against humanity, and the ICJ jurisprudence reflects on this. But you cannot analyze the single acts in a genocide as such. You need to take a step back, because the intent cannot be looked at as with a magnifier. You need to take a step back and look at the totality of the crimes committed, the totality of the conduct, against the totality of the people targeted as such. Doesn't matter scientist, baker, priest, imam, child on a wheelchair or not, talking to the mom, or looking at the sky, or bathing in the Mediterranean Sea. No one has been spared, because they were Palestinians, therefore killable, and everything that belonged to the Palestinian was destroyable. This is the philosophy or the ideology that has upheld this genocide. And in fact, proof of it is the fact that while genocide was rampaging in the Gaza Strip, similar acts have been enforced in the West Bank. The destruction of hospitals, the mass killing. This year, 840 Palestinians have been killed in the West Bank alone, including 180 children. 9,000 Palestinians have been arrested, the majority of them without charge, without trial. These are captives. How does it make them different from hostages? To an illegal occupation all the more, because Israel maintains an unlawful presence. Even the ICJ has come to this conclusion. Israel must withdraw from the occupied Palestinian territory. I'm sorry, this is the law. And there is this doesn't mean that the Jewish people cannot live in the land that has been recognized as the state of Palestine, the little that remain on their land. But they need to live as Palestinians if they want. This is the minimum bearable that the Palestinians can have, because this is what the international consensus is. Otherwise, they need to be recognized with political and civil, economic, social, and cultural rights within one state. There is no alternative. And so while acts of colonial erasure, annexation, forcible displacement, settlers violence rampaged in the West Bank, I concluded we need to see the colonial erasure. It's decades that Israel has tried to eliminate Palestinians from Palestine, not only physically, but culturally, in terms of identity, doing cultural appropriation from hummus to cultural venues and festivities. So again, genocide is not an act. It's a process. The genocide that is happening in Gaza from a legal point of view, where for genocide, we need to understand that legally, genocide is something much narrower than the term used in anthropology, for example. What is destruction of a people as such, including in its cultural and political elements. However, the jurisprudence is such that encompasses some cultural elements and recognizes that the destruction of the land and the forcible displacement can be an act corroborating genocide. So this is why I say, because this is the first act of the first genocide, settler colonial genocide, to ever be litigated before an international court. This cannot be missed, and the intent to realize greater Israel, and we shall not confuse the intent with the motives, because I've heard, well, no, but the intent of Israel was to liberate the hostages. No, but the intent of Israel was to eradicate Hamas. Motives? You can have 1 million motives. But the intent is not the thought. The intent is not the why. The intent is the fact that you have already decided. The intent is the determination to destroy. And Israel has matured the determination to destroy, also as part of its shock doctrine. Like the US, it has used an incident to provoke, to wreak havoc and to provoke mass damage, and taking advantage of it, take the land without the people. Well, this is genocide and not merely ethnic cleansing, because again, it has devastated Gaza, destroyed Gaza and its people. And the responsibility is of the state. And with this, I conclude. We cannot miss the responsibilities of the state, not only because the state individuals have called for it, but because this is a so-called rule of law system. So what has it done while, what did the parliament or the judiciary have done while Israel was advancing, while the executive or the army were advancing this plan? So you are responsible for genocide, also for incitement, for acts and omissions. And we cannot miss at least the opportunity to deliver justice to the Palestinians. And may this just be one part of the justice that these people will see, hopefully not too late.
Thank you so much, Francesca, for describing your findings about the genocide and the horrific facts about what Israel is really doing in the occupied Palestinian territory.
Indeed, a very difficult day to speak. I share the same sentiment with Francesca and Raji. It's difficult to speak today because of the sadism of the situation that we find ourselves in, where genocide is something that people can debate when they start and when they end it. And the fact that the world has normalized the process, the fact that the ceasefire discussions, which are basically discussing the illegal, Israel is discussing how far it can keep Palestinian prisoners while it has no right to keep these political prisoners who might also be deemed to be kept as hostages in their turn. And it's discussing how far it will have rights to control land over Gaza. It has no legal right to control anything in Gaza. So negotiating the illegal and taking up time that costs the blood of people in the streets. So I can't imagine darker times to be speaking. And on that note, I will start my discussion with a quote from Martin Luther King. I must make two honest confessions to you, my Christian and Jewish brothers. First, I must confess that over the past few years, I've been gravely disappointed with the white moderates. I've almost reached the regrettable conclusion that the Negro's greatest stumbling block in his stride towards freedom is not the white citizen's counselor or the Ku Klux Klaner, but the white moderate, who is more devoted to order than to justice, who prefers a negative peace, which is the absence of tension, to a positive peace, which is the presence of justice. He wrote this from Birmingham jail in 1963. And as we speak today, the moderacy of the liberal mainstream international legal discourse, as well as its own colonial and imperialist undertone, is what has led us to what's happening today. The genocide in Gaza was a completely normal development of the colonial story of Israel. As Abby Schlein would tell us, Israel was mowing the lawn in Gaza every few years, and genocide was inevitable. This was going to happen. Every single sign was there, and that's why Palestinians and people who've been working on this for years were ready the moment we saw the signs. Of course, Israel partook in atrocity propaganda in order to facilitate that. And again, had the world looked at lessons learned from colonization seriously, this wouldn't have happened. And the most typical space of the white, moderate, liberal international law is a place where the history of colonization is indeed erased. So I will structure my talk into three parts. The first one, I will speak about how do you read international law in such a context of extremity, looking at it and reflecting on it from a more of a global south-oriented and a critical perception. Then I'll provide a reading of the advisory opinion on the illegality of the Israeli occupation of Palestine, and moving then to different forms of going forward, understanding accountability and envisioning it. As I do that, I'll be responding indirectly to a lot of the points that have been posed thus far in the discussion. So first of all, when we talk about, and for those of you who have engaged with critical international legal scholarship, we have critical legal scholars talking all the time about the indeterminacy of international law and the fact that we don't have a solution, we don't have a final answer towards understanding what the rule ought to be. And here I'm referring to a scholar such as Marty Koskinemi and the like. When Marty Koskinemi speaks about scholars from the global south like Alvarez, He says that they speak about the question of justice, and it's a very indeterminate question. Who is there to decide what global justice looks like? And hence, the question of global justice is deemed irrelevant for critical scholars. However, I would argue to the opposite of that. I would argue that from the perception of colonized peoples, from the perception of dominated peoples and exploited peoples, the compass of justice is indeed crystal clear. Perhaps we could start with an international legal system that enshrines non-domination and non-exploitation as the premises of going forward. Alvarez, in the Anglo-Iranian oil case, called for a new international law that takes into account the experiences of states that were colonized, that takes seriously the experience of previously colonized states. That ethos did lead a lot of legal discourse in the 1960s and 70s in the United Nations. Sadly, that ethos was killed with the Thatcher and Reagan regimes. And here I'm talking about the new international economic order, the declaration on ending colonization, the declaration on friendly relations. These were tenets to try to think of international law in a different way, in a way that does not look into the positivist body of international law or Western legal thought as our main compass, but rather as global justice, as understood from the perception of those previously colonized. As it stands, the current body of international law is inherently in its structure sympathetic to both colonization and imperialism by design, either in its substance or its procedure or its practice and argumentation. Even if you try to speak the words of justice, you'll be stuck with bureaucracy. As we've seen with the case of Palestine, years after years, people, and you see generations among them is myself, of Palestinians who have sought to take this very clear sense of justice to the international fora. Little did we know that the moment we arrive there, we'll be met with windmills akin to the ones faced by Don Quixote, imaginary giants. We would find ourselves fighting with bureaucracies that were made in order for us to, at some point, simply lose hope because the stride is far too long. I've seen this effect of fighting with windmills on my most beloved people and the voices of justice. As we try to engage with international legal institutions, that structure obviously has been suffocating us. The most suffocating feeling, of course, is for over a year and a half of a genocide, trying to go and speak about it, as Raji very eloquently put. What people always tend to forget is that international law does not really happen in international courts, nor does it happen in the United Nations. Most of international law happens in the public. It happens in the media, and how the language of international law is being used and to shape international politics. And perhaps here is where I start on the optimist perception of how do we go forward. For us to go forward, we need to understand our engagement with international law as being inherently a political act, not one that academics do in separation or in journal articles, not one that people do within only the spaces of advocacy of the United Nations, but rather as a political act with the eye towards social justice. Once we see our practice of international law along that line is when we can revive the language of international law that could be steeped into the logic of justice. By that, I mean a harmonized reading of international law. A reading that comes towards people who would say self-defense and goes back to the primary premise of the UN Charter by saying, well, what have we learned about what upholds international peace and security? I'll elaborate on those points going forward. So this will be the backdrop of my engagement with international law. To be a Palestinian or to be an ally of Palestine who engages with international law, a very clear compass and understanding that you will only try to strategically seek spaces where international law speaks to that justice. And also, international law sells itself to the rest of the world as some sort of premise of justice. Meanwhile, we all know that it's a very politicized space, looks after the interests of colonialism and the like. But our job is to touch upon this insecurity of international law, the difference between its representation as a place that promises us global justice and as game of real politique when we look at it in practice, to remind it and to remind people of the illogicality of it, or so to speak, to remind people of the truth of that. Therein, we are talking about the language of international justice, not about the language of international law. With that ethos in mind, how do we look at the advisory opinion of the International Court that came out in July? So I was fortunate enough to work on this case as a consultant. And sadly, as we worked on it, it was very clear the ideological differences and the different approaches to international law that were taken. The main finding of the court was indeed that Israel is violating multiple Jus Cogens norms of international law. And by Jus Cogens norms, I mean preemptory norms of international law, the rules at the core of the international legal system that are meant to sustain international peace and security, and the rules that override all other rules. Here, I'm talking about the prohibition against aggression, the prohibition against racial discrimination and apartheid, as well as the protection of the people's right of self-determination. When we add those violations together, we get a very clear picture that sadly mainstream liberal international lawyers have been trying not to say. This is a clear image of colonization. What else can you call this? It is alien domination and subjugation in its most classic form given possible. And why do I say this even though this has become very clear? I say this because I argue that this ought to be the premise with which we imagine the Palestinian right of self-determination going forward. Self-determination is one of those rights where there is an absolute lack of imagination in mainstream international law. It is a place that doesn't reflect really on what happened in post-colonial states. For example, Palestine calling to be a state is a trap because most post-colonial states honestly gained almost close to nothing by just becoming states. That did not allow them to become sovereign actors. It did not allow them to have economic sovereignty, political sovereignty. And the reality is, when we study the history of previously colonized states, we find that self-determination in such contexts is indeed non-domination, non-exploitation, and non-intervention. These are the premises of that. Not to start to look for establishing a democratic system akin to Western democratic systems. That's a step that comes in later on. First of all, you have to end the illegality and in all of its forms. There is no democracy if the country is being controlled by foreign direct investors or if the country is in a race to the bottom in the international financial system. Who are we kidding? And why are we still stuck at that way of thinking? So in short, the Palestinian right of self-determination can only be understood as decolonization. This was affirmed in the opinions of Judge Youssef and Judge Iksu. I would add to that. The limits of the advisory opinion is that it talks only about areas that were occupied ever since 1967. However, we tend to forget that Israel is in violation of the duty to protect the right to return, which was conditioned for the establishment of the State of Israel, alongside the accumulated illegality of never paying reparations or repartition to the Palestinian people. So, aside from any political debate, the people's right of return, as clearly illustrated by Francesca, as well as the reparations that ought to be paid for the Palestinian people, are clear rights that have been infringed upon. So when we want to imagine the Palestinian right of self-determination, our imagination cannot be only limited to the areas of 1967. That way is a great way to deny the humanity and rights of over 8 million Palestinian refugees who were displaced from historic Palestine as we know it today. And these are people whose voices are pivotal towards practicing the Palestinian right of self-determination. So the court found that, in short, the Israeli presence in Palestine in its totality is illegal, full stop. Any Israeli foot in Palestine is not justified. And if the Palestinians want to express their will, they don't want any Israeli foot in Palestine. And what are the effects of that? So the effects of that are a lot. I will limit my reflections on just a few. I will start with the recognition of the Palestinian right to resist, which is indeed one of the most controversial rights there. And I would argue very clearly that the controversy over the right to resist is not a question of justice. It's a question of politics. Herein, the right to resist is indeed a clear demand of justice, as well as logic, as well as history. The Universal Declaration on Human Rights says that we will protect human rights lest people go back to revolting because human rights are not protected. When we go to the works of very mainstream international lawyers like Baxter, Lottepacht, and the like, we will find that they were very much all right with resistance during occupation of different places of Europe, the ghetto uprising, and the like. We find also nowadays that people are very much fine when Ukraine is resisting. So the gravity of the illegality at hand, and of course, we don't say that people have the right to resist in any context. In the Palestinian context, we have a right of a prolonged illegality where the international community is not seized on the matter. There is a lack of political will to engage on the matter for over 75 years. As well as indeed the fact that there is a clear violation of the people's right of self-determination. And the legitimacy of the right to resist comes directly from the right of self-determination. And the General Assembly itself did recognize the legitimacy of the people's right to struggle by all means available at their end. Endless amounts of times, really, in the 1960s and 70s, if you recall before, when I mentioned that as more or less a time where voices of the global South were asserted in international circles. And specifically in relation to Palestine, I refer to Resolution 3535 of 1980 that recognized the Palestinian people's right to resist. Furthermore, and not to go too far, Judge Hilliard Charlesworth, in his declaration in the current case that I'm talking about, the advisory opinion, asserted that the Palestinian people have the right to resist by referencing the fact that in the Hague regulations, the people do not owe a duty of allegiance to the occupying state. Again, a very logical rule. If we extend our perception to the Convention on the Prohibition of Apartheid, there we see that also the state committing apartheid also has the duty not to prosecute people for their resistance to its own illegal acts. Furthermore, states of the Global South, having clearly appreciated the importance of national liberation movements for the maintenance of international peace and security, because if we are to speak, and as someone who works on war economies, if we are to speak of international peace and security, and Israel is indeed committing crimes against international peace and security, not just in Palestine, but also in Lebanon and Syria, it is very clear that equality and the end of alien domination and subjugation are premises. Because without that, people will always have reasons for greed and grievance. People will always want to revolt, or there will be reasons for greed over natural resources. So, of course, adding to that, George Abu Saab had worked at the United Nations had spearheaded efforts towards the recognition of the legitimacy of wars of national liberation. And who is to represent the people? Whoever the people choose. And the existence of a state or a government does not omit the people's right to resist, because also in this case, the government is not functional enough to represent the people, giving the people an exception to that. For those who are interested, there will be a paper that will be shared with the overall outline of the right to resist. But in short, the fact that this always gets omitted from the news, from the public discussion, and highlighting the right to resist is indeed one important way towards paving the path for Palestinian liberation, which is to counteract the position where Palestinian liberation is simply seen, or Palestinian acts are simply seen as terrorism. And it's important not to equate resistance with terrorism. The acts of terrorism are acts that are in violation of the conduct of hostilities, and that is jus in bellum. the legitimacy of the acts of resistance is a question of use of force. It's use ad bellum. So people who partake in acts of resistance, of course, are indeed bound by international humanitarian law. And just because they have the right to resist, that does not justify any violation of international humanitarian law. And indeed, of course, this should have gone without saying. What about Israeli right of self-defense, which has been mentioned multiple times thus far? In short, in the Weyl case, the International Court of Justice had noted that Israel cannot claim self-defense against an area where it itself is an active aggressor. So you aggress someone and they fight back, you can't claim to be defending yourself against that act, which is quite a logical resolution. Furthermore, as Francesca kindly noted, Israel's right to, if it existed, its right to defend itself would have ended on the 8th of October, 2023, as the moment it was capable of repelling the act. The declared motive of eradicating Hamas is not a legal one at a whatsoever level. Not adding further to that, it is indeed one way to prove intent for genocide. Because if you eradicate one form of resistance today, another form of resistance will come tomorrow, because for very logical reasons of Palestinians just simply being humans who refuse to be subjugated by an alien power. And it is important to remember that Judge Tladi, in his opinion, also in the advisory opinion, made a very great commentary by saying that Israel always says that it's protecting itself or partaking in these illegalities for security concerns. What usually doesn't get highlighted is, one, security concerns do not override international law, but two, Israel's security concerns can't override that of Palestinians, in short. And that message extends to the US, because what the US keeps on saying is that NATO obligations override international law. And I'll elaborate on that going further. And it's important to remember that the NATO agreement does not override state obligations coming out of violations of US Cohn's norms. I will move to the last part of my presentation as to how do we imagine going forward. I will share what I say is a rather humble thing. I hope that now you can see my screen. Francesca, can you let me, or anyone can? Yes. Okay. Going forward is a long way. And as I always say, the case of Palestine is emblematic of all that ought to happen in relation to the rest of the global South. It highlights to us the structural inequalities that exist in our world, but also call for a new way and political engagement with international law. And the creativity and also the spaces that we've seen in engagement with Palestine can then be very much used towards an engagement with international law that tries to embed that sense of justice. So to start with, what is third state responsibility in relation to an illegal occupation and partaking in such violations, including, of course, the violation as well as genocide? So, as I said, in short, Israel is committing crimes against international peace and security. That is the highest level of violations you could imagine internationally. Taking the court's decision forward, the court said that states have to review their trade and investment agreements in order to ensure that they do not contribute to the illegal occupation of Palestine. So the first thing is in relation to trade. Now, states have a green light to end trade with Israel in vital industries that feed the war economy. And here, based on our studies, and there will be a webinar with Law for Palestine in a couple of weeks where a trade lawyer will explain this at length. For the time being, the focus would be on tech, energy, and military, and of course, halting any trade with the settlements in totality. The argument there is that under Article 21 of the GATT, there's an exemption for states in relation to when they need to uphold their obligations under the UN Charter. Hence, they can violate their trade obligations. Of course, we've been talking a lot about an arms embargo, and there is no way to go against the idea that an arms embargo against Israel is an international legal obligation based on the duty to prevent, the duty to cooperate towards ending the illegality at hand, the duty of non-recognition, and as well as the duty to protect, duties under the Arms Trade Treaty, as well as what the Human Rights Council said in April. And I'm not even naming all of the sources of that duty. Three-way embargo is an international legal obligation. No buying, no selling, no transiting weapons. Meanwhile, for corporations, responsible disengagement from any acts that contribute to or benefit the continuation of the illegal occupation. For investment, end all investment agreements that are relevant to the occupied Palestinian territories and those where the profit feeds into the war economy. Again, looking at the tech, energy, and military industries. So here we have a green light to breach agreements and international treaties. That is because Article 53 of the Vienna Convention tells us that when you have an obligation under a treaty that is in violation of a jus cogens norm, that obligation is void. And we faced that in relation to Egypt, for example, when through the Suez Canal, there was a transit of weapons that was going to Israel. And when confronted with it, Egypt said that it has obligations under the Constitutional Convention. And the main response to it was, and again, very logical, the duty to prevent genocide in this case overrides duty in that treaty, which again should have gone without saying, if we are to be logical about things. So how are things imagined forward? This is again a very humble map based on what people have already been doing. First of all, on national action. Criminal cases against persons, if you've all noticed the work of the Hind Rajab Foundation alongside others that are tracing persons who partook in the Israeli military efforts. Further, this can be stretched to people who are officials in corporations that contributed to and benefited from the ongoing genocide, as well as the illegal occupation and anything happening in the West Bank. So the scope is quite humongous. And here, most of these cases were relying on international criminal law, as well as a tapestry of relevant national laws. Furthermore, freedom of information requests. So, for example, in Belgium, activists relied on freedom of information requests under environmental acts to see where the transit of shipments with the Zim company were going. And based on that, they were able to then target their own advocacy. So as well as requests for the declaration of legal advice given that was used here in the UK in order to see what type of legal advice did the government get. Administrative and civil cases against the state in the UK. Now there's a case that will be heard earliest in March in relation to the UK's licensing of arms. We are also looking at a decision by the court in the Netherlands, hopefully in this month, also in relation to that choice. And here, if I might note, a very small caveat, which is that these states have instilled a carve-out for the F-35 program warplanes going to Israel. And there they cite the idea that NATO obligations are their priority. And here states must be reminded of what I said previously. Furthermore, and one of the biggest challenges we are facing going forward is U.S. coercion. And by that, I mean any state that is abiding by its third state responsibility is being faced with the threat of trade sanctions by the U.S. And of course, this is something that states of the Global South were very aware of very early on. And in the annex to the Vienna Convention on treaties, there is a prohibition on the use of economic coercion. What we see by the U.S. is indeed a form of economic coercion, and it needs to be called out. And of course, we see very similar acts of defunding. People who work at the UN are expecting that the next few years will be quite difficult with the U.S.'s move to defund everything. Here, I would argue that perhaps this is the time to move the UN outside of the global north, welcome it to the global south, and look at this change perhaps with a hopeful eye rather than a pessimistic one. Another mechanism here is feeding information to state bodies. That has been quite consistent, talking to your MPs all the time. I have talked to MPs in multiple states, and really the level of ignorance that you find is insanely intolerable. Legal support for boycott campaigns is severely required, as well as the capacity to navigate or to question sanctioning laws. local council acts. That has been also a movement in multiple places in Europe. Organization via unions. Shareholder activism is quite also an interesting mechanism in corporations that are complicit with Israel. Cease and desist. Meanwhile, as to international actions that can be taken forward, submissions to the UN, excessive amounts of them, mechanisms, ICC, lobbying the UN General Assembly Resolution, Human Rights Council, and again, here I have to stress, with an eye and knowledge of relevant resolutions. Sadly, the main reason, and I have to reiterate this on and on again, the main reason why we haven't seen an arms embargo resolution at the UN General Assembly is the Palestinian Authority. And the Palestinian Authority is under its own corrupt leadership, but also under different forms of coercion and behavioral power, controlling it, not going forward, which is very unfortunate and which sheds another light of complexity to the Palestinian case. Palestinian Authority does not represent the Palestinian people, and this provides a very interesting complexity of navigating international mechanisms and indeed a way to break down a lot of the efforts done thus far, then with regional actions. I realize I ran out of time, so on that note, with my humble, I hope I managed to, I'm happy to answer further questions, specifically in relation to litigation around the arms trade. And there is an abundance happening now, and we expect an avalanche of litigation going forward, despite the exhaustion until the system breaks. So, as noted by my colleagues, this is indeed an existential moment, not just for Palestine, but also for international law. And this is a moment where the sharpness of violence has led us to see truth in its eye. And this truth is not unique to Palestine, but really to the world system as it stands. The only way we can pay respect to the lives lost ever so inexplicably in ways we cannot imagine, really, like this, in the words of the UN Charter, has scarred the consciousness of humanity in a way that has changed all of us. The only way to give that meaning is for this to be a moment of accountability and a moment where the liberation of Palestine is not as simply a dream, but rather something that is happening in action. And not only that, for the liberation of Palestine to be emblematic, a point of juncture that brings people under domination and exploitation around the world together under one banner that allows us to instill some sort of logic going forward that could influence other discourses, such as the climate crisis and the like. Thank you very much, and I appreciate the time, and sorry for going over.
Thank you so much, Shahd, for your analysis of the Palestinian people's right to resist in the context of self-determination, the self-determination right, and the legal responsibility of third states and corporations, as well as strategies to further Palestinian liberation. Thank you. Maria LaHood next.
Thank you, Marjorie. I'm so honored to be on this panel with Raji, Francesca, and Shahd, and so grateful to them for their tireless work to try to stop this genocide and for Palestinian liberation. Any progress toward justice that we've seen is because it's been hard fought by Palestinians first and foremost. The ICC arrest warrants were only issued because Raji and other Palestinians have been working so strategically to demand justice and accountability for decades. And Francesca's powerful interventions as Special Rapporteur and Shahd's excellent scholarship have been critical to help try to bend international law toward justice. We know that power concedes nothing without a demand. Every day of the last 466, we've watched the massacre, mutilation, and starvation of children live streamed. As Raji said, 17,000 children have been killed. As Francesca mentioned, thousands have had limbs amputated. At least 47,000 Palestinians have been slaughtered, likely so many more at the hands of Israel and the U.S., while the whole world watches. I fully agree with Raji. The U.S. is not merely complicit in Israel's genocide. It has been its full partner and bears just as much responsibility. The U.S. government has been providing Israel the vast majority of the weapons and other military equipment used to carry out the genocide and unconditional support and diplomatic protection to ensure it continued. The timing of this potential ceasefire is around U.S. politics. There's simply been no political will to make it happen sooner. I'm going to first talk about the work we've been doing in the U.S. to try to end the U.S. role. CCR and co-counsel Vanderhout brought a case on behalf of Palestinian human rights organizations, Al-Haq and Defense for Children International Palestine, as well as 3 Palestinians in Gaza and 5 Palestinian Americans in the U.S., against President Biden, Secretary of State Blinken, and Defense Secretary Austin for aiding and abetting Israel's genocide and failing to prevent it. In 1988, the United States ratified the Genocide Convention through legislation that then Senator Joe Biden co-sponsored, and it enacted the Genocide Convention Implementation Act, making genocide and complicity in genocide a federal crime. We brought the case under federal question jurisdiction and under the Alien Tort Statute, which gives federal courts jurisdiction over a limited number of international law tort claims brought by non-U.S. citizens. It's a statute that CCR pioneered the use of in the 1970s to bring international human rights claims in U.S. courts. After filing the complaint in November 2023, we brought a preliminary injunction motion to urgently stop U.S. support for the genocide, including with declarations from our clients and from genocide experts. The world's leading genocide legal expert, William Shabas, concluded 14 months ago that there is a serious risk of genocide against the Palestinian population of Gaza and that the U.S. was in breach of its obligation under the Genocide Convention and customary international law to use its influence to prevent it. The case was also supported by several amicus or friend of the court briefs at each stage of the litigation, including by NGOs from all over the world. We were able to put on live testimony at a hearing in a U.S. court over the government's strenuous objection. So a year ago, on January 26th, the day the ICJ issued its provisional measures, ordering Israel to stop its genocidal acts, our clients were able to testify in a U.S. court about the ongoing Nakba and the devastating accounts of their loved ones being killed in this genocide. Our Palestinian clients courageously went up against the Biden administration and created a powerful historical record and helped shift the narrative. There were 1,000 people watching on Zoom, and the 4 hours of testimony lives online. The federal court agreed that Israel was plausibly committing genocide and implored the administration to reconsider its unflagging support. It also said that it's every individual's obligation to confront the current siege in Gaza. But the court decided that it lacked jurisdiction, finding that whether to provide support for Israel is a political question for the executive. But the courts have a duty to adjudicate the legal question of whether the U.S. was aiding and abetting genocide, which can never be a discretionary policy choice. We appealed, but the Ninth Circuit Court of Appeals affirmed the dismissal, finding that the political question doctrine precludes courts from adjudicating claims rooted in international law that strongly implicate U.S. foreign policy, as if international law has some lesser standing. This sweeping and dangerous decision leaves the judiciary in the U.S. without any power to say what the law is whenever international law and foreign policy are implicated, much less hold the executive accountable. The political question doctrine has been distorted from the constitutional principle of separation of powers, in which the judiciary decides legal questions, not questions for the political branches, to a deference to unbridled executive power in the entire realm of foreign policy, resulting in utter impunity. And of course, it's the executive that decides when to even assert the political question doctrine. In a case in Texas to enjoin Biden and Blinken from funding UNRWA or making other funds available for assistance in the West Bank or Gaza, the government didn't even argue that the political question doctrine precluded adjudication of those claims. When we asked the full Ninth Circuit to rehear the case en banc, not one of the 29 judges asked for a vote. If the law, including international law, is not applied universally, it's just another tool of empire, and it's up to all of us to enforce it. States are defaulting on their legal obligations, so it is up to us. There were 2 new civil cases were brought last month in the U.S. Another, Maria mentioned one of them in the chat, so you can see the link there. Taxpayers Against Genocide constituents brought a class action against 2 members of Congress in Northern California who voted to approve $26 billion in military aid for Israel last April, arguing that they violated the Constitution when they voted for the aid because taxes can only be used for the common defense and general welfare of the U.S. The nonprofit Dawn brought a case on behalf of Palestinian families against Secretary Blinken, challenging the State Department's failure to implement the Leahy Law, which prohibits U.S. assistance to Israel security forces when there's credible information that they've committed gross human rights violations, which Obviously, there is. Litigation is just one tool of many, but it can be part of the resistance. Even if cases don't win in the courts, they create a record, build power, raise awareness, and mobilize the movement. Complicity is everywhere around us, not just with our elected officials, not just the weapons manufacturers and tech companies, but every culpable corporation, every university, every dual national in the IOF committing war crimes in Gaza should be held to account. Many Israeli soldiers are filming and posting their crimes on social media. Many are dual nationals, and there are efforts to pursue them and hold them accountable wherever they live or travel. Shahd mentioned the Rajab Foundation, which is tracking dual national Israeli soldiers, going through images and videos online to collect and verify evidence. There are more than 23,000 U.S. citizens serving in the Israeli military. There are 4,000 French dual nationals. The Rajab Foundation has submitted the names of 1,000 Israeli soldiers to the ICC with evidence of their crimes, and they've filed dozens of criminal complaints around the world, including in Argentina, Chile, South Africa, Thailand, Sri Lanka, Belgium, France, Norway, Sweden, and Brazil, either where the perpetrator is a dual national or where they're visiting. Just recently, the Brazilian court ordered police to open an investigation into claims that an Israeli reservist who was on vacation in Brazil had committed war crimes in Gaza by planting explosives and destroying people's homes. He then fled the country with Israel's help. Israel is now warning soldiers against traveling abroad to avoid arrest and instructing them not to post evidence of their crimes. Of course, Israel is not instructing them to comply with international law and avoid committing crimes, much less holding them accountable. Under the principle of universal jurisdiction, courts exercise jurisdiction over internationally condemned crimes regardless of where they were committed, and often without the state having a connection to the perpetrator or the victim. Most countries have domestic legislation permitting some kind of universal jurisdiction. As Raji mentioned years ago, when criminal cases were previously brought against high-level Israelis and Americans for war crimes, several countries yielded to pressure by Israel and the U.S. to restrict the scope of their UJ laws. It's a constant struggle to enforce the law against imperial power. The U.S. Department of Justice has a Human Rights and Special Prosecution section whose mandate is to prosecute genocide, war crimes, and torture. Before Netanyahu came to the U.S. last summer, CCR asked DOJ to investigate him and other Israeli officials who visit the U.S., as well as U.S. officials complicit and the many U.S. citizens serving in the Israeli military. DOJ has only opened an investigation into Israel's crimes once, and that's for the killing of journalist Shireen Abu Akleh, but it has not charged anyone for that crime after more than 2.5 years. Even when we have legal victories, as with the ICC arrest warrants and the ICJ's provisional measures and its advisory opinion, the struggle goes on to actually implement those decisions and end this ongoing genocide, occupation, and apartheid. There are many forms of resistance in seeking accountability, and we all have a role to play. As Shahd explained, all states are legally obligated to end complicity in Israel's genocide, illegal occupation, and apartheid regime, and we must push our governments to end their complicity. We must press all the levers of justice. The fight for international accountability includes challenging complicity wherever it is and advocating for boycotts, divestments, and sanctions. The call from Palestinian society has been to boycott, divest from, and sanction Israel until it complies with international law. The ICJ's ruling that Israel's very presence in the OPT is unlawful makes clear that BDS is not only a moral duty, it's also a legal duty. And in September, the UN General Assembly voted for sanctions on Israel. It's up to each of us to find and target those complicit and hold them accountable. Student protesters on campuses across the U.S. have been demanding their universities disclose financial investments and divest from companies or cut ties with academic institutions complicit in Israel's violations. And dozens of universities across the world are committing to take those steps. There have been grassroots campaigns targeting members of Congress and other targets all over the country and building power in communities. Real change is happening on the ground and it will only continue to grow. One target is Israel bonds, which people have mentioned in the chat. Local and state governments are investing taxpayer money in bonds to support Israel, and communities are organizing to stop them through campaigns and litigation. Following sustained pressure from its members, the UK's biggest private pension fund divested over $100 million of Israeli assets, including Israel bonds. Community members brought a case against Palm Beach County, Florida, which is apparently the world's largest investor, investing about $700 million in Israel bonds, arguing that the investment is not based on financial return, but on social and political beliefs, breaching their fiduciary duty. There are also legislative campaigns. For example, CCR and partners have worked on a campaign to pass legislation in New York, the Not on Our Dime campaign, to stop the flow of money from nonprofits to the Israeli military and settlements. States won't enact an arms embargo, so people are engaged in direct action, trying to stop the transfer of supplies that enable Israel to continue its crimes, protesting at docks, preventing ships from carrying military supplies to Israel. And as Shahd mentioned, she can go over the arms embargo litigation that's happening around the world. Israel fears the power of the global community to isolate it, to enforce international law, and has said in the past that BDS is the biggest threat it faces, which is why Israel has been building the infrastructure to suppress BDS for at least the last 15 years, attempting to eliminate support for Palestinians, to isolate and eliminate them, to distract from Israel's international crimes, and to try to win its narrative war. The worldwide repression against advocating for Palestine is an extension of Israel's crimes in Palestine. The crime of apartheid includes persecution of organizations and persons by depriving them of fundamental rights and freedoms because they oppose apartheid. That repression is apartheid when it's committed for the purpose of establishing and maintaining domination by one racial group of persons over any other racial group of persons and systematically oppressing them. Just as efforts to suppress advocacy for Palestinian rights have grown exponentially in the U.S. in the past 15 months, we'll continue to see growing efforts to undermine and destroy international law and mechanisms. Raji mentioned Trump's prior sanctions on the ICC prosecutor. A week ago, the House of Representatives passed the Illegitimate Court Counteraction Act, the ICC Act. The law would rescind and prohibit funding to the ICC and sanction any foreign individual who engages in or aids any ICC effort to investigate, arrest, detain, or prosecute U.S. citizens or citizens of an ally that has not consented to ICC jurisdiction or isn't a state party to the Rome Statute. It also makes individuals and their immediate family members inadmissible to the U.S. and freezes their U.S. assets and prohibits all transactions with them, which would impose civil and criminal penalties on those providing them with support, not only financial support, and it would potentially include lawyers representing victims before the ICC, like some at CCR. And the legislation states on its face that it's because of the investigation and arrest warrants for Netanyahu and Gallant. It still needs to be passed by the Senate, which could happen in the next week, and then signed by the president. So it's not too late for people in the U.S. to reach out to your senators. In 2020, when Trump imposed similar sanctions by executive order against the then ICC prosecutor and another official, it was after she had requested a determination on the ICC's jurisdiction over the Palestine situation and after an investigation was opened into U.S. torture in Afghanistan and CIA black sites. Trump could easily issue another executive order without even waiting on the Senate to pass legislation. There were a couple cases challenging the 2020 executive order. One was brought by law professors who had provided assistance to ICC investigations and prosecution and wanted to continue doing so. And the court issued a preliminary injunction on First Amendment grounds that covered plaintiffs and the specific conduct they were engaged in. There will certainly be challenge to any upcoming law as well. Meanwhile, the U.S. government has lauded ICC arrest warrants against Putin and Sudan's al-Bashir. This is just another example of the U.S. using the law and international mechanisms as yet another tool of imperial domination. But each of us has the power to help make international law live up to its promise as a tool of justice and accountability for everyone. Thank you.
Thank you so much, Maria, for analyzing the litigation and legal strategies to stop U.S. complicity in Israel's genocide and the BDS campaign to end Israel's illegal occupation. Well, thank you to all of our faculty. This has been one of our best programs at the People's Academy of International Law, and we're just delighted that you were able to join us. We now have a short period where the faculty members can interact with each other and comment on each other's presentations, and then we will take questions which have been put in the Q&A box and some in the chat from all of you. So are there points that any of the faculty would like to raise or respond to or add to our discussion?
Yes, Shahd said about the right of self-determination, because she said there is an absolute no imagination among legal scholars about the right of self-determination. And this is so true. And I would like to say, especially to the young ones in the audience, that you cannot learn self-determination. It's very hard to understand self-determination if you need to read it on legal books and on legal books written by Western scholars. But I would like Shahd to elaborate. The second question is for Maria. Maria, I would like you to say something, if you can, about whether you see the significant forces playing against justice for Palestine that are on the horizon are going to hamper the quest for justice in the US. And if you can comment abroad as well, or this will motivate more people to seek justice given to the political impasse that will be palpable, probably in the United States and in its vassal Europe. And the last question is for Raji. Raji, as a Palestinian from Gaza, how do you see the future? Thanks. Very briefly, if you can.
So should we take that in order first? Shahd, would you like to respond to Francesca's question?
Absolutely. So, as I said, my conflict with the right of self-determination actually started when I worked on the case, and you could see the huge divergence in it, especially between scholars from the global south and scholars from the global north. And whenever you ask people, they're like, self-determination is having a state and democracy, full stop, which indeed undervalues and overlooks completely what you would learn when you read the other literature, which is literature by decolonial scholars, Mrs. Fanon, the work of Thomas Sankara, and you'll find that their self-determination is understood to start with the ethos of no one will exploit us, no one will dominate us. And you could see a much stronger ethos of justice. And when we want to think about the Palestinian right of self-determination, I'm always afraid of the following, that they will reroute us to process, to be stuck in process rather than substance. So you want self-determination, let's create more institutions. Let's talk about this model and that. And that's exactly what the poverty in Western legal literature in relation to self-determination would end up doing. Instead of people simply, I don't need to go and ask the Palestinian people, what do you want? At the moment, it's very clear what they want, and the compass is very clear at the moment. We need to start doing it. And indeed, I can't build anything healthy on top of something that is rotten. I will quote here a very lovely quote that I found from a scholar called Knudsen, and she says that, I'll put the citation in the chat, but she says that manifestations of self-determination in international discourse have been characterized by the presence of two conflicting ideas of freedom. While the liberal conservative idea of freedom has been given priority to the value of peace, the radical idea has brought equality to the fore. And this really reminds me of Kwame Ture's quote when he says that peace is a white man's word and our word is justice. And for self-determination to be this imagination of Westphalian state institutions rather than a drive towards justice as expressed through also the lessons learned from colonization. You want to see the future, look at what colonized people have said. And perhaps this is my invitation based on your question for people who are really struggling with the Palestinian question. A shift now to epistemologies of the global south and reflecting on the writings of people also like Walter Rodney and the like are of the essence. Again, not just to understand the work of Palestine, but the world. And these works have been completely erased actually from what you would learn in university, even in the critical circles, because, and even in the work of Lasordo, he says that even in Marxism, these themes of imperialism and colonialism in mainstream teaching of it have been eradicated or overlooked. It's as if these lessons from history are lost, and now we can't imagine. how to go forward. And not only that, when we don't have an imagination how to go forward, we can be easily distorted, and we can have different faces of power that hold on to cultural understanding of what Palestinian identity is, but all give us the same liberal understanding of and more or less neoliberal conservative understanding of how we should go forward. And perhaps this is me also using the language of justice to provide also economic social justice imagination of the future of Palestine. But yeah, thank you.
Thank you for that, Shahd. Maria, would you like to respond to Francesca's question?
Yeah, sure. Thank you for that question. You know, certainly the assaults on speech for Palestinian freedom and critical of Israel can be chilling. But we continue to see the movement growing exponentially. More and more people are brought in with every act of suppression, with every act of violence, and it just exposes the larger strategy of Israel's domination and oppression. And suppression works by creating a climate of fear. So the most important thing to do is not to be chilled, not to be silenced. Use the assaults as opportunities to discuss the real issues, to change the narrative, not just the free speech principles, but the issue of Palestinian self-determination and freedom, of Israel's genocide and apartheid, of U.S. complicity. It takes work, and the more people doing that work, the sooner we'll see a free Palestine.
Thank you, Maria. And Raji, how do you see the future per Francesca's question? Raji, I think you're muted.
Yes, Marjorie. Many think that the Palestinian-Israeli conflict began October 7th last year, which is a grave mistake. The Palestinian-Israeli conflict in the short version, 57 years, and in the long version since Nakba, it's 76 years. So there is deep, long conflict, and the massacres, I mean, against Palestinians were crimes against humanity, persecution, began in Deir Yassin, and it didn't end up there, up to Sabra and Shatila and to Gaza. So we have deep, long conflict, and the Kafka that in this conflict we have the most well-documented conflict in history, thanks for the human rights organizations and revisionist historians and for the people who wrote all that history and put it in the most fantastic, professional, scientific way. So we are talking about very, very prolonged conflict, very well documented conflict, and it's simple to say that Palestinians are on the right side of history, and they have just the right cause, and they have all the reasons, I mean, to believe tomorrow will be theirs. But I'm saying that while we are in the midst of genocide process, it's on our skin, and we are paying dearly and heavily right now. I mean, we are talking to each other. People are slaughtered, starving, displaced, and nobody can claim we didn't know. They know it. They see it. I never, ever thought that Israel will come to this. I know the Israeli politics. I know the Israeli political mentality. I know the Israeli different ideologies of political parties. I know about their history, but I never, ever thought they will come to this at the daylight and to be supported, protected as such. This is unprecedented. You do live stream genocide, and those who claim we are civilized, we have standards, we have ethics, they are partners by protecting, supporting, and even providing with arms. They didn't satisfy with that only, but they are attacking the most important legal justice system on earth. They are threatening the ICJ and the ICC by the President of the United States, by prime ministers, by congressmen, by parliamentarians, by major political actors. It's obscenity. And it's very dangerous and very critical and very crucial for us, definitely as Palestinians, but as well, for the rest of the world. The selectivity and politicization of international law, so rude, so ugly, and I don't know where this is taking us to. We cannot give up with all that, because if we give up, that's what they want, and that's why they are looking for rule of jungle, guns, blood, and they are mighty, and they are powerful, and they will impose their conditions and rules at the end of the day. That's why I think what should be done, basically, I think we contributed and we will continue contributing with our share as a human rights activist, as lawyers, as people who are advocating for justice and dignity, for rule of law. But I think, there is a big mission in the West, not only for the academics, for the scholars, for lawyers, but for defending the creme de la creme of the human values we jointly believe in. And definitely what, for example, CCR, Maria, and her colleague did in the US with the case, this is one bold example. Really trying to use this effectively within the American legal system, within the European legal system, but that's not only. I think the ICJ, with its advisory opinion on 19th of July, put a framework for a plan of action for states, for civil society, what to do, how on this illegal occupation Palestinians can practice their right of self-determination. These bodies should enable them, should help them. ICJ don't have army, ICJ don't have executive power. The states, the UN bodies, and civil society do have, and that's, the way how to go onward. There is quite a lot of homework waiting for us. The challenge is big, real, serious. It's not only, related to Palestine. It's related to humanity, what world we want, world with the rule of law or world with the rule of jungle. But me personally, I never give up. I believe, on the Palestinian level and international level, we began to collect forces and we began to join forces. Our presence, loud and clear, it's obvious. They are in real dilemma, but we have to maximize that. They want us to lose hope in tomorrow. They want us to lose our strategic optimism. Never ever will give up. It's not a human to give up. It's not a human to be good victims for genociders and the criminals. And our humanity imposes on us our role as a human rights activist, as jurists, as lawyers, as active in civil society who believe in this set of international law, which is the creme de la creme of the human experience. We have to hit hard, we have to work hard, and we have to keep the strategic optimism all the way along. For the foreseeable future, I don't think it's going to be easy. I think it's going to be bleak, black, and bloody, but we are not going to reward anybody the fact they are genociders and criminals. Our dignity in defending our principles, in defending our people and the victims.
Thank you, Raji. We have our work cut out for us. And strategic optimism, I think we need to keep that all squarely in mind. I've tried to consolidate some of the questions, and I'm going to put them all out there together, and then any of the faculty who want to respond can, because we are short on time. Is the U.S. the sole obstacle to justice for the Palestinians? And would the removal of the veto power in the Security Council help overcome this legal barrier? How can we as lawyers and activists who believe in human rights come together to reform the international legal system? And what is the role of the General Assembly? What can we do to change the vision of people in the West about Palestine and Israel's genocide? And how can we defeat anti-BDS laws? Are there active campaigns that are engaged in this? So any of you who would like to respond to any of those questions, please feel free.
I have 2 points I can reflect immediately. One, regarding U.S. U.S., we are suffering from U.S. policy in Palestine more than the Israelis. And I'm sure if U.S. stopped loading Israel with arms, they ultimately, they will stop bombing and killing us, in Gaza. U.S. just providing total blind support for the Israeli policies against us. And I think genuinely and really that U.S. absolutely partner in this genocide. I have no doubt on the professional or conscious level. We have serious problem with governments. How can I understand in the Netherlands, the Prime Minister of Netherlands says, well, if Prime Minister Netanyahu come, we will find a way to protect him and not to hold him accountable, while they are the host of ICJ and the ICC. It's big shame, big shame. They disrespect everybody intelligence. They don't know, why they hosted them then. If you don't respect their decisions, why you call The Hague the capital of peace and justice? Tell the world it's the shelter for genociders, as simple as that. So there is real serious problem, and I don't think this problem exists with the people. We are heartened and we are positively shocked how the world people reacted in Japan, in New York, in Chicago, in San Francisco, in DC, in South Africa, in London. In London, 2 million people, went to the street. Fantastic. How this was in Spain, Ireland, Luxembourg, Norway, all over the place. People showed for the last 15 months their ongoing support. I think the problem in these rotten colonial mentalities, the racist mentalities in these Western government, they are shaping up differently. They are more bloody and they are more sacrificing, international law and world order. So there is, real serious problem for us, with U.S. Sometimes, as a Palestinians, as a stupid Gazan, I'm asking myself, what is the problem between the 17,000 children of Gaza to be killed by American bombs? Why U.S. hate them as such? They want to get Hamas. They want to get Fatah. They want to get Jihad Islamic, PFLP. Get them. Why you are killing the civilians? Why they are in the eye of the storm? It's so bloody and so evil and so unwise. You are just raising generation who are fed up with rage, with anger for the injustices they are having on their own skin and they are facing, not in Palestine, but in the entire region.
I think we are just about out of time. I just want to note that students on university campuses in the United States and around the world are bravely resisting the U.S. role in supporting Israel's genocide, and we should commend them and support them in any way we can. I also want to say that the People's Academy of International Law is a project of the International Association of Democratic Lawyers. Raji, the Palestinian Center for Human Rights, and the Center for Constitutional Rights